federal special program Capital Beat. Supreme Court has said that 2nd August onwards, it will begin the hearing on the pleas which challenged the abrogation of Article 370, also resulting in the bifurcation of the Jammu and Kashmir. Now, Centre had also given an affidavit to the Supreme Court saying that after the abrogation of Article 370, the state registered an unprecedented progress, security, and stability, which was completely missing during the old Article 370 regime. Now, the million-dollar question is that the court, of course, will begin the hearings to almost like 23 petitions, but can Chief Justice of India, D.Y. Chandrachud, actually restore the Article 370 in the Kashmir state? Joining me now is veteran Supreme Court lawyer and activist Prashant Bhushan. So thank you so much for joining on the Federal. And so my first question to you is that the Centre had submitted an affidavit and the Supreme Court has very clearly said that this affidavit will have no bearing on the constitutional validity. Now, what is going to be the ambit of when the Supreme Court starts looking into?
So there are 3 questions before the Supreme Court.
But just 1 second, sir. Just 1 second. What happened, Arun? You didn't press the record button. Arun?
No, ma'am, we are on live. Please
okay.
continue.
Okay. No, because okay. Yes, sir. Go ahead, please. Yes.
So there are 3 questions before the Supreme Court. One is whether using the provision in Article 370 itself, which says that apart from the subjects mentioned in the instrument of accession, which would be with the Centre, the President can make such other modifications, etc., and apply some other parts of the Constitution also to the state of Jammu and Kashmir. However, that can only be done with the concurrence of the state government. So the first question is whether the consent of the governor at a time when President's rule has been imposed in Kashmir can be construed to be the consent of the government.
Okay.
This is the first question.
Right.
Then they have further used the whole another provision in 370, which says that 370 itself can be repealed with the consent of the Constituent Assembly, with the approval of the Constituent Assembly of Jammu and Kashmir. So the second question is, can they have done 2 things. First, they have said that Constituent Assembly means Legislative Assembly. This is an amendment that they have made in Article 367. And then they say that when the Legislative Assembly is not there, when President's rule has been imposed, then the Legislative Assembly's will is expressed to be taken as the consent of the Constituent Assembly after that amendment in Article 377. That amendment has been made through a presidential order. Now, so the second question is whether this can be done. That is, instead of the Constituent Assembly, you make a change to say Legislative Assembly. And that too, you are amending one provision of the Constitution without taking it through the Parliament or through the 2/3 majority in both houses, etc., to make that constitutional amendment. And secondly, you are just using the consent of the governor to be the consent of the Legislative Assembly. So this is the second question, whether you can do that. And then the third question, of course, one of the questions in the first question is, can you just wholesale do away when Article 370 says that you can make changes and apply other provisions? You can apply some other provisions of the Constitution also to the state of Kashmir with the consent of the state government, whether that would also include just applying the whole Constitution to the state of Jammu and Kashmir with the consent of the state government, because that effectively amounts to abolishing 370. And for abolishing 370, you need the consent of the Constituent Assembly. So whether by just using the state government, and state government meaning governor, you can do that. So that is the other question. And the last question is whether you can bifurcate a state, particularly a state like Jammu and Kashmir. Firstly, you can reduce it to a union territory and then bifurcate it into 3 union territories, whether the central government or the president can do it without even, firstly, can they do it at all? Can they make a state into a legislative assembly under Article 3 of the Constitution? Because under Article 3, you can merge 2 states, you can divide up states into 1 state, 2 states, etc. You can do all those things. But can you convert a state into a union territory, and then can you then bifurcate the state into 3 union territories without even for doing bifurcation of a state, etc., you require the views of the Legislative Assembly. Here, have not even done that, because you say कि President's rule tha, and therefore I have taken
Right.
of the governor. So these are the questions. Yeah, go ahead.
Yes. The Supreme Court all of a sudden has realized that, it needs to hear the petitions now. All these 4 years, there was nobody had heard from the Supreme Court. And Mehbooba Mufti has also raised this point, that she expresses some kind of an apprehension as to why the leaders visited Kashmir and then suddenly Supreme Court has started, has decided to begin the hearings. And she says that it evokes some kind of a misgiving. Now, what would you say to the delay which the Supreme Court, we saw a delay of almost like 4 years after 2019. What would you really say to that?
Yeah, that was very unfortunate. Of course, the Supreme Court did start hearing the case at one point of time and heard it for several days. Thereafter, the issue was whether it should be referred to a constitution bench or a 7-judge bench, etc. And that hearing got aborted. And after that, it was not resumed. It's now being resumed after more than 2 years with a new bench. And the new bench is the 5 senior judges of the Supreme Court. No, I don't think there is anything suspicious about their hearing the case at this point of time. It was long due for hearing. It's high time that it was heard. And I'm glad that they have fixed a date for hearing it.
But so the $1 million question now is that whenever the arguments begin from 2nd August onwards, of course, the court will look into the constitutional validity, the way the Article 370 was abrogated. But where does the government of India legally stand? Does it stand really on a very, very weak wicket when it comes to the legal provisions, how it dissolved the assembly and how the Article 370 was abrogated? Legally speaking, will the government really face some difficult times once a hearing?
My view, the government's case is completely untenable because for several reasons. Firstly, that Article 370 was brought in pursuant to the limited instrument of accession of the state of Jammu and Kashmir. It was in the light of that if Kashmir acceded to India with conditions, and the conditions were that the state will be given a very high degree of autonomy, and that only three subjects would be with the parliament, and all the other subjects would be with the states, and that it would have its own constitution. Now, given that these were the reasons and circumstances in which Article 370 was brought, it must be treated to be a basic feature or part of the basic structure of the Constitution, which means that it cannot be amended. Now, 370 itself provides the manner in which other subjects can be brought into within the purview of Parliament, etc. And the manner in which 370 itself can be abolished. So it says that so far as bringing in other subjects under the purview of the union list is concerned, or applying other provisions of the Constitution to the state of Jammu and Kashmir, you will have to take the consent of the state government. And in this case, clearly no consent was taken of the state government. They are saying governor is the state government. That is totally wrong in my view. Secondly, they have effectively, in the guise of bringing in some other provisions of the Constitution or bringing in some other matters into the union list for the state of Jammu and Kashmir, they have wholesale applied the whole Constitution to the state of Jammu and Kashmir.
Right.
So
that what you said. But what you said that this case is completely untenable when it comes to the legalities of which the government of India has adopted. But does that mean that the court could end up taking a very adverse decision, and which means that it could upturn Article 370?
Yes, they can restore Article 370. They can hold, and they should hold, that that the manner in which 370 has been removed is completely unconstitutional. That the manner in which the state has been made into union territories is completely unconstitutional. The manner in which the state has been bifurcated into three is also completely unconstitutional. They can certainly hold that, and they should hold that. Because
sir, to be honest, do you expect that the court will go to that extent, and probably it might find a middle ground because a decision has been taken by the parliament and Article 370 has already been abrogated? So many people say that probably a middle ground could also be a path which the court could adopt. And what could be that middle ground then?
You see, the thing is that unfortunately, the court often gets influenced by practical politics or by public opinion, etc. But the duty of the highest constitutional court in the country is to follow the law, the letter and spirit of the Constitution. And if you follow the letter and spirit of our Constitution, you can see that Article 370 is a basic feature, that the Article 370 itself provides of how changes can be made to the state of J&K, and it's been very careful. They've been very careful that if there are some changes, they can be made with the consent of the state government. If there is wholesale repeal of 370, that can only be done with the consent of the Constituent Assembly of Jammu and Kashmir. Unfortunately, far from taking the consent of the Constituent Assembly or the Legislative Assembly or even the state government, they have done everything through the governor by imposing president's rule. And governor, who is just a tool of the central government in practical terms.
Right. But sir, despite all the legal challenges which the government might face, and the way the government is trying to justify is the manner in which, the post abrogation Article 370, how the life in Kashmir is. And also if you look at the affidavit where they said that it has brought unprecedented progress, stability. Now, and they've also been saying that, we've not tried to discriminate against the people. We need one constitution. We need one flag. Now, this is the narrative which the government politically and also legally is trying to, dole out before the court. Now, will the court really buy this argument by the center?
See, this is a sort of psychological thing that they have tried to use on the court by filing this affidavit saying that everything has been normalized and that Kashmir is now very normal after the abrogation of 370, etc., which is firstly not true. It's not true for several reasons. If it had been true, what prevented the government from holding elections in Kashmir? Even a union territory.
They also said that there have been district development council elections. They've said that in the affidavit also.
Those are all farcical. You see, firstly, there has been a lot of terrorist incidents in Kashmir after this. There has been a lot of terrorist incidents there. So therefore, to say that the state is completely normal is not correct. Secondly, if it was totally normal, they should hold elections in the states, in the three union territories also.
Right. Also, the way the special rights were snatched away, from the people of Jammu and Kashmir, Article 35A, when it comes to reservation of jobs for the people in Jammu and Kashmir, would court also, if at all, I mean, it's quite speculative because we do not know what's going to happen. But if the court at all adopts a middle ground or a middle path, could the court also end up, making some special provisions for the people of J&K and at the same time, let the Article 370 where it is right now? Could that also be an issue?
I don't know what the court will do. I mean, strictly speaking, the court should decide the issues that are before the court in a purely constitutional legal manner.
Okay.
It is not the job of the court to make some kind of practical compromise about what is to happen in Kashmir and give this and take that and so on and so forth. They have to decide purely on the basis of the law and the constitution.
But many political analysts say that if there is an adverse decision by the Supreme Court, as in if the Supreme Court tries to restore Article 370, it could lead to a lot of violence and, it would lead to some kind of a fusion, of the people's sentiments in Kashmir. What would you really say to that? Again, that's quite speculative, but sir, can you hear me?
I don't see why there should be violence if status quo ante is restored. I mean, why should there be violence if for more than 70 years or for more than 70 years there was a particular situation which was prevailing? And if that situation has been changed in the last 4 years, and if that situation which was prevailing for 70 years is restored, why should there be any violence on account of that? In fact, the people of Kashmir will normally be very happy that the greater autonomy has been now given back to the state of Jammu and Kashmir, which was part of the instrument of accession, which was very carefully engrafted in Article 370, etc. And that they get back that autonomy.
One last question, sir, before I wind up the interview. So you do believe that this was one of the biggest blunders made by the Narendra Modi government, maybe the constitutional blunder or a judicial blunder, if I may say?
Yes, in my view, it was a very big constitutional blunder. And in my view, also a big political blunder. Now, it may have helped them to win the elections or rather gain some popularity in the rest of the country, but that's not the true test of whether something is in national interest or in public interest, etc.
You are saying that, and you're sure that the court probably will not take into account other considerations because it's completely untenable.
No, I can't say what the court will take into consideration or not take into consideration. I'm saying that the court has often in the past been influenced by public opinion or by general pressure of the government, etc., etc. But I hope that in this case, they will go purely by the letter and spirit of the Constitution.
Right. It was a pleasure having you, sir, on the program. Thank you so much. And one appeal to the viewers who are watching the Federal, subscribe to our channel, send us your feedback. Stay tuned to the Federal. Thank you, sir. Thank you so much.
Thank you.
Thank you, sir.